Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. Let me formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get status and their green cards in the United States. I am also here at 9 p.m. every night to take your questions, and this is no exception. So you can start putting any immigration related questions in the comments and I will go ahead and answer your questions. So can you tell me about the I-751 waiver? Kruti Patel, this is awesome because I was just going to talk about that. I was just going to talk about this process going from the 2-year green card to the 10-year green card, and that included the waivers. So I'm going to actually start with the waivers tonight. So now what Kruti Patel is talking about is when you're going from a 2-year to a 10-year. So your marriage was only 10 months. Okay. So there are 3 ways. So if you're going from a 2-year to a 10-year, normally you have to jointly file when you're renewing, right? You have to renew within 90 days before the card expires. And when you do apply, you normally have to apply jointly with your spouse. That means that you and your spouse have to sign the document, the I-751 application, and send it in with evidence to show that you continue to have a bona fide marriage. This 2-year green card is given to individuals who are applying through their spouse, and then their spouse, at the time that they are approved, they have been married for less than 2 years. You would get the 2-year. It's kind of like a probationary period where they want to make sure that you have not gotten married just for the green card. And so they require you and your spouse to apply jointly to be able to get the 10-year green card. Now, there are certain situations where the marriage doesn't work out, or there may be circumstances where you're unable to file jointly with your spouse. And in cases like that, there are some cases where you can apply for a waiver. Now, waivers, you can apply for waivers at any time during this 90-day period, application filing period, or even afterwards, where if you're filing jointly, you must file timely within this 90-day period before your card expires. If you don't, you have to have a very good reason why you missed the deadline. With waivers, even if you've already submitted your I-751, you can submit a waiver. Now, what is a waiver? A waiver is basically a way to request that you it's a way to request that you can for permission to apply without your spouse. So in a case like this, if you know that you will not be able to file with your spouse, it's time to think about a waiver. And now, whether you apply within that 90-day period is really going to be a strategic move. You have up until that 90-day period to apply. If you've already submitted your application with your spouse, or if you were unable to because of issues going on with the marriage, you can always submit the application after the fact with the waiver. Now, to qualify for this waiver, to be able to apply for the 2-year renewal to a 10-year green card, you will need to show that you've gone through a divorce. So you would have to show the divorce decree, and along with the divorce decree, you would have to show that your marriage was still bona fide. Even though it didn't work out, it was still bona fide. Also, if you are not separated, so if you're not separated, but even if you're divorced, but you were also mistreated or abused or subjected to extreme cruelty, you could always apply for a waiver on that basis as well. And then the last is through extreme hardship. If you will experience extreme hardship, if you don't get the green card, or get the renewal from the 2-year to the 10-year, that could also be a way to basis to apply for this waiver. So let me take a break to answer some questions. Do you help with visas? So some sorts of visas, yes, I absolutely help with them. You can call 561-405-4889 and go ahead and schedule a consultation to talk more about your particular visa, or you can even ask her. So me and my ex are still taking it can hurt my are still talking. It can hurt my case. He's not ready to remarry right now. So Kruti, it's what you need to evaluate now is, since you are separated, and if your spouse is, it really depends on the situation with your spouse. If your spouse and you are divorced, then that could be a way for you to apply for this waiver. In addition to that, also show that your marriage was bona fide. It just didn't work out. Now, this is where a consultation is very important, because keep in mind that while I'm giving you general information, it's not personal legal advice, and this general information could very much change just depending on the facts in your case. So very important you schedule a consultation. Can you seek an asylum when you have overstayed your visitor's visa? That could be a possibility. Keep in mind that there is a 1-year deadline. So you must apply 1 year, up to 1 year after your entry to be able to still qualify for asylum, or have a good reason why you didn't get to meet that deadline. So maybe change of circumstances or exceptional circumstances to show why you didn't meet that. In addition, keep in mind that asylum is for individuals who have a credible fear of persecution if they should return to their country because of they are part of a particular social group that is being harmed in some way, targeted by the government, or a private group that the government is not controlling. So that is also something that you would have to look at. And if you really have that fear, a credible fear of returning to your country because of this, because you feel like you'll be harmed, definitely schedule a consultation and let's talk about your particular situation. So Wally the King, hi there. Thanks so much for the compliment. So we are divorced. So yes, so once you're divorced, then you definitely are going to have to file for that waiver based on the divorce, and also show that you had a bona fide marriage, even though it didn't work out. Responsibilities to come back to show I don't plan. So if I were to come on an ESTA with proof I have responsibilities back home, then marry. Can that work? Responsibilities to come back home to show I don't plan to stay. So when you are coming into the country on a temporary non-immigrant basis, you have to make sure that you don't have the intention at the time. And so if you get the ESTA, a part of that is to show that you definitely will return to your home country after a temporary visit. Now, whether or not you can come and then get married and then a stay is really going to be dependent on your particular circumstances to determine whether that can work in your situation. Definitely schedule a consultation, and we can talk more about what your situation is. Let's see. So our action, I don't see the rest of your question. Can you retype your question, please? So what is the difference between the I601 and the I601A? So the I601A is, and thanks so much for the roses, I appreciate it. So the I601A are for individuals who are applying for the provisional unlawful presence waiver while they're in the United States. So these are individuals who they only have unlawful presence as their immigration violation. So there are no other issues, and they just are seeking forgiveness for the overstay or the unlawful presence, to be able to get the forgiveness, travel to their home country to attend the final interview at the embassy. The reason that's important is because they don't qualify to adjust status in the United States. And so they have to figure out a way to get to the U.S. Embassy in their home country or in a country of their choosing without facing that 3-year bar or the 10-year bar. Remember, if you overstay over 180 days, you will face a bar of 3 years if you leave the country. That's going to trigger the bar. Leaving the country is going to trigger the bar. If you overstayed over a year, that turns into a 10-year bar. Now, if that's the only thing that's preventing you from attending going to the embassy to be able to complete your green card process, the I601A, if approved, will fix that situation. And that's where I like to say, fix your status. That waiver basically fixes your status and allows you to go and get the green card. Now, the I601 covers other inadmissibilities, other types of inadmissibility, so misrepresentation, criminal inadmissibilities, as well as health-related inadmissibilities. What are the firms to file for to bring my husband from overseas? So I am the U.S. immigration attorney at ST Law Office, and that's exactly what I do. So it's called consular processing, where you sponsor your spouse to come to the U.S. on an immigrant visa and to be able to get their permanent residence. So if you would like to go ahead, go to the link in my bio. It'll take you to the website where you can go ahead and call. So there is a scheduling coordinator who is available up until 11 p.m. tonight, and this is also applies Monday to Friday between 9:30 a.m. and 11 p.m. There's a scheduling coordinator who can take your call and schedule the consultation, where we first talk about your situation, and then I talk to you, I advise you on the process, and then you can walk out with me as your attorney should you choose to hire me. What if you are against taking the vaccine? You have to cancel your appointment. That is definitely going to be up to you. So nobody is necessarily forcing you to take the vaccine. However, if you are going to go through the permanent residence process and you're going to go to the medical exam, they're going to evaluate you to see if you have received a vaccine. And this is now one of the listed requirements for the vaccination. Now, there are exemptions in cases where it's truly justified. So, for example, if you're a part of a religion and a part of your religion is that they have been opposed to vaccines, not necessarily all of a sudden being opposed to the COVID vaccine, but it's established in your religion that you are against vaccines, then that could be an exemption. And another thing is if the vaccine is not widely available in your area, the doctor could provide a waiver, or if the doctor believes that it's inappropriate. So if you're not if you, for some reason, for health reasons, you don't qualify for the vaccine, the doctor will also provide a waiver at the physical exam. So thanks so much for the roses. My brother was deported about 15 years ago. Can he come back to the U.S.? That is possible. It may be possible. That's where a consultation is very important, because that's where you can get to know, I can get to know what those issues are, what caused the deportation, and then determine how to fix that. Chevrolet 37, thanks for the follow. The consultation fee is $150 for up to an hour, and it is worth it because you walk out of that consultation knowing your options, knowing whether you have better options, knowing how to approach your situation, avoiding mistakes that can turn into expensive mistakes personally and financially, and you can walk out with me as your attorney should we both determine you need that help. You're welcome, Kulabosa. So what are your fees to file for husband who's at overseas? So Wally the King, I can tell you the consultation is $150, and that's where I advise you. I first ensure that you qualify for what you want and the path you want to take in the immigration process. And then based on what you want, based on how we are going to approach your situation, I provide you a specific code. My fees are a flat rate. So once you do pay the fees, it's very predictable. It's not going to be by the hour. And so that's what I can tell you. However, the amount of the fee is going to depend on what your issue is and how we can approach it. How long is it taking for the forms to process? So it depends on what forms you're referring to. So it varies. But on a whole, the immigration process, you definitely have to be patient. A lot of it does take time. And so that's a frustrating part. But the specific timelines is really going to depend on what type of application. Can you become a citizen without being married to a citizen? If not, what can you do to become a citizen? So the first thing is you have to be a permanent resident to become a U.S. citizen. So you first have to make sure that you qualify to become a permanent resident. And then from there on, if not through marriage, if not through the military, it's generally 5 years until you can apply for citizenship after becoming a permanent resident. I am based in Boca Raton, Florida, but keep in mind, Krati Patel, I am a U.S. immigration attorney, and that means that I have a federal practice. I am not limited by state lines or borders. If you have a U.S. immigration process, you're anywhere in the world, you are anywhere in the United States, I represent you, and I do have my clients all over the world and the United States. My husband is a 10-year green card holder. Can I file for my son who is in Jamaica? So Monifa Love 44, if your child qualifies as your spouse's stepchild, then your green card holder spouse could apply for your child, for your son. However, if you don't have your status here, you wouldn't be able to directly file for your son. And also, if he's a 10-year green card holder, how long has he been a green card holder? Is it possible for him to file for U.S. citizenship? Right now, U.S. citizenship could take anywhere from 2 months to a year for some people, but my cases have consistently been 2 months to 6 months. Now, that is not a guarantee that will happen in everybody's case, because every case is different, but that could also be an option. So Monifa Love, call, schedule a consultation. Let's talk about the situation and come up with a good solution on how to get your son here from Jamaica. I'm trying to fill out the I-864 forms to get my family to the U.S., but it's not going through. So that is where you definitely would have to schedule a consultation. But keep in mind, I don't prepare the forms unless I am actually representing my client. So I'm not going to sit in the consultation and review your forms because I just have limited time to advise you. So you can definitely ask me questions about the affidavit of support, but I'm not going to sit down in a consultation and review forms that you're going to fill out, because that's a liability issue as an attorney, and so I have to be the attorney. So if you do have questions, you need legal advice regarding your process, definitely call, schedule a consultation, and we can see what's going on. How long does it take to get a green card? So it depends. So if you're the immediate relative of a U.S. citizen, that means you're the spouse of a U.S. citizen, the parent of a U.S. citizen who's 21 and up, or you're the son or daughter of a U.S. citizen under 21 and unmarried. Those are immediate relatives of U.S. citizens in immigration law. That's taking about 18 months, maybe even up to 2 years. But 18 months is the average. If you are over 21 or over, you're the son or daughter of an unmarried son or daughter of a U.S. citizen, 6 to 7 years. If you're 21 or over, the son or daughter of a green card holder, 5 to 6 years. If you are the married son or daughter of a U.S. citizen, you're looking at about a 12-year process. If you are the sibling of a U.S. citizen who's 21 and up, you're looking at a 14-year process at minimum. In Mexico, it's taking about 20 years right now. If you're the son or daughter of under 21 and unmarried of a green card holder, or you're the spouse of a green card holder, you could be looking at the same 18 months to 24 months right now. Thanks so much for the follow and sharing the live for those of you who have done that. Thank you so much. Can a sister file for another sister? Yes, so a U.S. citizen's sister can file for their sibling as long as they're 21 and up. But keep in mind, it's not a quick and easy solution, and it's not going to fix your status if you're here in the U.S. It's unlikely to do that just because it takes such a long time. My husband is a permanent resident. He filed for my I-130 in November 2020. No approval as yet. So just keep in mind that it is taking up to a year or even over a year to get decisions on the I-130. So just keep up on your case, check the status, and make sure they haven't sent any requests for any information from you. My fiance and I will book with you soon. Kula Bossa, I'm looking forward to speaking with you, and I know all too well how this process is and how frustrating it can be, and I will work hard to work with you. And let's start with that consultation first. Thanks, Jesse Graham 754 for sharing the live. How long does it take for a sister to file for a sister who is in Jamaica? So it's taking about 14 years right now. So very long, and you have to be invested in the process. The good news though is, if that is the only way to qualify for permanent residence, that sister could carry any of her children who are under 21 and unmarried, as well as her spouse. If a parent passes away waiting for the daughter to get status, what's possible? So there is something called humanitarian reinstatement, where someone else can step in and provide an affidavit of support, but the I-130 would have had to be approved before the parent passed away. So that's going to be a timing issue, and I definitely want to talk to you in a consultation. I am Nika Marie. I can't wait to speak with you. Thanks for booking. We received the receipt and check the receipt. Info daily, no change yet. Is there another way to check? So no, that honey bun sunshine, that is going to be no. Another thing is, you can always submit an inquiry if it's taking more time. If your processing time is over the processing time at the service center. So you can check the service center that's processing your case. You usually can tell by the 3 letters in the front of your receipt number. You can, if you search the service center by going on the homepage of the USCIS.gov, then you go to case processing times, search for the case, the service center, and look at the range of time. If you're over, there are ways to do a case inquiry to figure out why your case is taking longer than their average. And sometimes that can tend to give them a nudge to process your case. And there's also called congressional inquiry, where when I am representing my clients, if it does get to that point, I do submit a request to my client's representative, and they can look further into the case as well. Grandpa died 2019, U.S. citizen 2008. Can grandkid born 1997 become a citizen? So no, grandkid. No, it really depends on how that went. So the grandpa became a U.S. citizen. Did the grandparents were the children of the grandparents citizens as well? Because while a grandchild can't necessarily directly derive citizenship from the grandparent, if parent derives citizenship from the grandparent or from the grandparent and they didn't even know it, then they were citizens all along, then the grandchild could derive citizenship as well. But that's going to, of course, be more than figuring out the dates that he died. But it's going to also involve the parents. Where were the parents? Did they become U.S. citizens? But grandkids don't automatically get citizenship from grandparents. How about a child filing for his mom? So a child filing for his mom, you know, a child, not a child, but it's usually the adult, so son or daughter, 21 and up, who applies for their parent. They're the only group that can apply for their parent. That one is taking about 18 months. How long does it take for a fiance visa to be processed for a spouse of a U.S. citizen? Right now, it's taking a little over a year. So it's taking over a year right now. It's California and it changes all the time. So honey bun, what you need to do is, even though it changes all the time, you need to see if you're outside of that processing time. So if the range they're giving is 6 to 18 months, are you at the 20-month mark? And if you are, then that's where you can submit a case inquiry. A fiancé visa process, is it easier to obtain green card through this process? Not necessarily easier. It just depends on your personal preferences. Do you want your fiance here? Do you want to get married in the U.S.? Do you want to take your time and not get married in the foreign country? Right now, applying for the fiance visa is taking over a year. And so is applying for your spouse, like if you went to the country and got married. And so both processes are taking over a year. The fiance visa comes with different steps. So first you get the fiance visa, then your fiance comes on a 90-day visa to the U.S., then you get married, then you go through the green card process, which is a hassle in itself. Because after going through all of that, you then have to go through it again to get the permanent residence for your fiance turned spouse. However, with the spouse immigrant visa, what happens is you could get married and then apply for your spouse. They would attend the interview, get the immigrant visa, and then come into the country on the immigrant visa and become permanent residents at the airport. So it's really based on your personal preferences, your circumstances, and what works for you. So it takes less time for a green card holder to file for a child than a citizen. So no, that is not true. So keep in mind that right now, the green card holders, and the green card holder is current. It's taking about 18 months on average, but you can prepare for a 2-year process. Right now, green card holders sponsoring their children could, there was a longer processing time because they have to wait for an immigrant visa number to become available. However, there are less applications than there are immigrant visa numbers available. So now it's current. And when it's current, then yes, they are on the same timeline or around the same timeline as U.S. citizens sponsoring their children. However, the difference is where that is always the case, where a U.S. citizen will never have to wait to apply for their child who's under 21 and unmarried. A green card holder may have to start waiting for longer processing times when more applications start going in than there are immigrant visa numbers and a wait list starts again. So I'm excited about that though, because it gives other people opportunities who are separated from their families to get here. So when they're green card holders, because they don't normally get that. U.S. immediate relatives of U.S. citizens always get that opportunity, and it will always be a faster process than the other categories. So I'm excited when other individuals do get a chance to get a faster processing time, because they don't always get that opportunity. What's the average cost to obtain USA status? So it depends on what's going on in your case. How long does it take for a fiance visa to process? A little over a year. My mother applied for my sisters in the 90s, missed the appointment by years. Is anything possible? That is where we would definitely have to schedule a consultation to determine what happened. And when was the interview, and what happened throughout the process. You may have to refile though at this point. I don't know. I'm not the attorney. I don't know your facts, and that's where the consultation is very important. What if your fiance is a veteran? How long will it take to get a green card social? So it's the same. Hi there, Natasha. It's nice seeing you too. Bonafide. So my citizen hubby, whirlwind romance, married in 3 months but filed after 1 year. Word is a red flag but bona fide. That's where we'd have to do. If there are particular issues you're concerned about, definitely schedule a consultation. What I can tell you is, and it's reassuring, is I have had cases where that has happened and they have successfully gone through the process. Now, if you're living together, you are doing everything that a married couple should be doing, then you should be able to go into that interview, even if the officer is skeptical at first, as long as you can provide them the evidence to reassure them or convince them that it's bona fide. That's what the interview is all about. But this is where I say schedule a consultation and let's talk about your particular circumstances and determine whether there is something that could cause a red flag. How long does it take for a USCIS to mail your green card after you received a welcome letter? So it could be a matter of a few weeks to months. Right now there is a backlog, and so it's really gonna it can range right now. Everything is a little erratic when it comes to those things. Should I wait for my spouse to get citizenship before I apply for a green card after overstaying? So it's it depends. There are different there are different options. So it really depends on how long will it take for your spouse to get a citizenship. If he has to wait a full 5 years, then you could possibly go through the waiver process. And so that is where you would definitely have to schedule a consultation to get more advice. And to determine which way would be better, because both ways could work, but it depends. If your spouse is like a month away from getting U.S. citizenship, then that definitely would be a great path. But if your spouse is years away from getting U.S. citizenship, then you could evaluate your other options. Hi, what if the asylum case is denied? What steps should I take in the future? That's going to depend on what's going on in your case. What other options do you have available to you? I'm a citizen and my mother is a green card holder, might become a citizen. Who is better to apply for my sisters? So definitely it would be your mother, because that is taking a 5 to 6 year process as long as your sisters are unmarried. And if they're 21 and over, they have to be unmarried though for your green card holder mother. But that's taking 5 to 6 years, where you as a sibling would take 14 years. Are you a criminal immigration lawyer? So I don't go to court. I don't defend individuals in criminal cases. However, once their case has been completed or while their case is pending, I do advise on the criminal aspects of it in order to assist my client with or their attorneys with how should they plead, whether they can get lesser charges to minimize the immigration consequences. And I also deal with waivers that are related to immigration consequences. Yes, we have lease, credit cards, insurance, power bills, travel itineraries, and pictures together. So those are definitely all great pieces of evidence. Will applying from a specific center for a foreign spouse application that would be less than a year. So it really depends. I mean, there are so many different embassies that process, and so right now most of them are backlogged and most of them are not taking less than a year, but it could be. But there are so many, it would really I wouldn't be able to answer that. How long after biometrics appointment do they issue the work permit? So work permits are issued 6 to 8 months after the filing. It's very erratic right now with the biometrics appointments. Some people's biometrics appointments are being scheduled a month after applying, some 4 months after, and so it's hard to determine how long after the work permit is issued. My husband's grandmother filed for him. How long before he can file for his citizenship? So 5 years after he gets his permanent residence and he's had it for this. Do text, WhatsApp screenshots also count as strong evidence? So absolutely, you can submit your records, phone records, call records, text messages, and WhatsApp and any other forms of communication. I have applied for the appeal after denial. Is there any chance of getting appeal pass? So yes, that it could be, but just nor Nagi, that's where you're going to have to get a consultation, because how likely you are going to be successful on appeal, it depends on what happened in the denial. I filed for more than 60 days ago. I never received a receipt notice. What do I do? So in some cases, you can call the number and ask them, to let them know you haven't received the receipt notice. And sometimes they will search to see if they do have your application. I filed for my mother since last year. I'm a citizen and haven't heard anything. So the I-130s are, and it depends on the processing times of the service center. So you can check the service center to see what their processing times is. If you're outside of that, you can definitely look into that. So everyone, I have a live that is scheduled on Instagram. We don't have to end the conversation here. You can hop on to Instagram with me. Now, all you have to do is you have to just go to the link in my bio. It'll take you to the website where you can go to the immigration attorney at Instagram. That's my handle. As soon as you get there, then you can hop on and continue to ask your questions. Thanks so much for all of your questions. If you can't join me on Instagram right now, then what you can do is you can join me tomorrow at 9 p.m. Eastern Time. I'm here every night at 9 p.m. to answer your immigration related questions. So it's not the end of your opportunity to ask questions if you don't hop on to Instagram with me. I'm here every night, usually from 9 to 9:30 or a little after 9 to 9:30. So thanks for your questions. If I didn't get to your questions, hop on over to Instagram. I'm the immigration attorney. You can follow me and then join me on live there. I'll see you soon on Instagram. Also, if you're listening and you know for sure that you will need a consultation, go ahead and go to the link in my bio again, but this time go to the website. There's a contact form, there's a phone number, and there's also the online chat. Scheduling coordinators are available up until 11 p.m. Monday to Friday to take your call and schedule your consultations. So I am looking forward to hearing from you, speaking with you in a consultation, or seeing you on Instagram in a minute or tomorrow on live. Have a good night, everyone.